Good afternoon, our attendees. Very happy to welcome you on our today's webinar. Thank you for joining us for today's webinar on protection of investments in the renewable energy sector of Ukraine. We on purpose waited a couple of minutes to allow more attendees to join before we start, since we prepared really interesting materials and we have really outstanding bright speakers to share with you insights. So we would really love to have all these insights and practicalities be heard by you. We will provide you with the most recent updates on perspectives of feed-in tariff regulation, options for protection of your investors' rights, and dwell upon practicalities and useful tips. We will also present you results of our recent market survey, the main goal of which was to identify key points of investors and key pain points for investors and ascertain their readiness to resort to legal remedies to protect their rights in anticipation of the announced feed-in tariff restructuring law, or I would say feed-in tariff cuts law. You are kindly invited to ask your questions throughout the webinar to the speakers, to all, or to some selected speaker. We will apply every effort to answer them during the webinar or afterwards through follow-up emails. So I would like first to start with a brief introduction. Since the autumn of last year, there were numerous discussions about the optimal model of feed-in tariff restructuring, and finally, on 10th June 2020, the Memorandum of Understanding on feed-in tariff restructuring was signed. The memorandum was signed between the government of Ukraine and two NGOs, being Ukrainian European Energy Agency and Ukrainian Wind Energy Agency, represent a significant number of renewable power producers of Ukraine. In principle, any renewable power producer may accede to the memoir by sending a letter to the Ministry of Energy. But as I know, until now, there is no producer of electricity under the feed-in tariff that co-signed the memorandum. And the reason for that, of course, is clear and straightforward, as by signing it, the company hardly gains any advantages, but rather potentially weakens its position if it would decide to resort to court. Notably, the memorandum is not a legally binding document, but rather a political framework outlining subsequent steps and obligations to be further formalized with the aim of resolving the current crisis in the sector. On 15th June of Parliament, as many of you know, the draft law has been registered. The draft law, initiated by the government, generally corresponds to the larger portion of commitments fixed in the memorandum. Interestingly, one of the key discrepancies, because there are discrepancies between the memoir and actual draft law, so one of the key discrepancies is a feed-in tariff cut by 60%, right? 60% for solar power plants with installed capacity of 1 megawatt or more with pre-PPAs that were commissioned since that will be commissioned since 1st August 2020. Under the memorandums, those were not eligible on feed-in tariff at all, with only auction options left available to them, while in the draft law they are still eligible, but the project economics would be so much damaged by this. The alternative draft law, authored by the Member of Parliament, Mr. Garus, was registered yesterday. However, until now, at least I checked half an hour ago, the text of this alternative draft law has not been available. The targeted deadline for passing the law on feed-in tariff restructuring is end of July this year. So before actually the RADA, Ukrainian Parliament, goes to the summer break. If the law is passed, the feed-in tariff cuts shall apply retroactively in relation to the power plants commissioned prior to the date when the law on feed-in tariff restructuring is in force. The level of tariff cuts depends on the installed capacity and commissioning date. According to the draft law, the reduction of feed-in tariff shall be as follows. So it's 15-10% of solar for solar, 7.5 and 2.5 for wind. So it all depends on the installed capacity, on the commissioning date, and the tariff costs would apply also to power plants commissioned before 13 June 2015, where the maximum level is set at the amount of slightly less than 22 euro cents. As already mentioned, the feed-in tariff for solar power plants with installed capacity of 1 megawatt or more with pre-PPAs that will be commissioned since 1st August 2020 will be reduced by 60%, as you could see on this table. And the rate, so the rate will be as low as 4.5 euro cents per 1 kilowatt hour. This handy table gives you very good insight and understanding from which you could clearly see that solar power producers were given less favorable treatment, and so it's no surprise that the biggest outcry emerges from exactly solar power producers. In addition to feed-in tariff cuts, the draft law proposes increased liability for electricity imbalances for facilities with an installed capacity of more than 1 megawatt. It's 50% liability for imbalances for companies starting from 1st January 2021. Again, as I mentioned, it applies to those with installed capacity more than 1 megawatt. And 100%, meaning full liability for imbalances, are starting from 1st January 2022. The increased liability for electricity imbalances does not apply to facilities with an installed capacity of up to 1 megawatt, I mean less than 1 megawatt. For such facilities as before, the gradual introduction of liability for imbalances is set first from 1st January 2021. So it's 10% with a subsequent increase of 10% each year until reaching 100% in 2030. And the tolerance margin is also decreased. Unfortunately, it's 10% for wind and 5% for solar. And so we can definitely conclude that the draft law provides for feed-in tariff cuts, not restructuring, and those are not voluntary but mandatory, and without any extension of the feed-in tariff for at least 1 or better 2 years, as had been requested by investors on really numerous meetings with the government. Further, it is important to stress that in addition to protection of investments under relevant bilateral investment treaties and the ECT, the legislation of Ukraine contains a number of guarantees to the foreign investors and producers of electricity from renewables. So basically, we can say there are already guarantees, or there is already stabilization clause in effective legislation, and we can say that the investors are to a certain extent already protected under effective laws. There are numerous provisions and few laws which are interesting to look at in this perspective, but I would mention just a few most interesting. If we can look at the main law, which is on alternative energy sources, it directly prescribes that the state guarantees for the whole period of the feed-in tariff the requirement on offtake of all electricity produced by the power plants from renewable energy sources that have not been contractually sold directly to consumers, the power supply companies, under the established green tariff. And in volumes, what is important, in volumes and order established under electricity market law. And the payments for such electricity shall be made in full, on time, and with monetary funds. Further, the law prescribes that the state guarantees that the electricity produced from renewables they are entitled for stimulation of production of electricity from renewables established in accordance with the provisions of the law as of the date of the commissioning of such objects, and such stimulation framework shall be applied further on. And in case of amendments to legislation regulating this procedure, business entities may choose and use stimulation procedures, voluntary, so it's up to investors to choose new. So at least this is a declarative provision fixed in the law as of now. If we talk about guarantees in electricity market law, it is directly stated there that the guaranteed buyer is obliged to purchase from producers for which the green tariff is established all output electricity produced under green tariff, or for which auction has been awarded auction lot, and for the whole period of the green tariff. Again, interest guarantee, which is also relevant to green producers, is that when dispatching the transmission system operator, TSO, shall give preference to such producers from renewables, of course, provided operational safety is observed. And the TSO shall apply measures to eliminate restriction on the production of electricity from renewables. Also, it is important to mention that there are other guarantees applicable to foreign investors that are provided in a number of legislative acts, including the law of investment activity and the law of investment regime. Interestingly, the latter directly prescribes that foreign investors have the right for compensation of damages, including lost profits and non-pecuniary damages caused through actions or inaction or undue performance by the state bodies of Ukraine or its officers, or the statutory obligation as prescribed in relation to foreign investors. So currently, the off-taker keeps on accumulating debts towards power producers from renewables. As of 15 June, its payments for electricity producers for this year, 2020, under feed-in tariff regime amounted only to 29%, or slightly more than 6 billion Ukrainian hryvnias of all payments due. And so the deficit is huge. There is also deficit of payment from TSO. The deficit that emerged at guaranteed buyer is also due to the debt of TSO before the off-taker. And currently, such debt amounts to more than 13 billion Ukrainian hryvnias, which is equivalent to roughly $500,000 US dollars. So having said this, as you could clearly see, Ukraine stands now on the very edge of pursuing a path of some other countries like Spain and Italy and Bulgaria, where the market was stroked by deficit of payments and simultaneously retroactive changes to the regulatory framework on feed-in tariff. And so, having said this, I'm very much honored to introduce to you our outstanding speakers, leading specialists in commercial and investment arbitration with outstanding experience, who have agreed to shed light on ways of protection of investors' rights, their legitimate expectations, and, as I hope, would infuse some enthusiasm to our attendees, investors in renewables in Ukraine, by way of sharing some insights and most practical considerations. So let me first introduce Jose Ferris. Jose is a partner in the International Dispute Resolution Practice Group of Squire, Patton, Boggs, and Ferris, specializing in international commercial arbitration, public international law, and investment arbitration. Moreover, Jose is a former Deputy Secretary General of the ICC International Court of Arbitration, where he supervised thousands of international arbitration cases and reviewed an equal number of arbitral awards in a wide range of jurisdictions and economic sectors, including energy. Also, let me introduce John Branson, who is a partner in the International Dispute Resolution Practice Group of Squire, Patton, Boggs in New York office, and acts in particular especially complex high-value matters with a focus on commercial and especially investment arbitrations. He represents clients in cross-border disputes across a range of industries, and his experience includes representing foreign sovereigns in international investment disputes. So please welcome our speakers. The floor is yours.
Thank you, Tatiana. Next slide, please. And so just by way of background, for those of you who are less familiar with Squire, Patton, Boggs, we are a global law firm. We have 1,500 attorneys across 44 offices in 20 different countries. I think in particular, international dispute resolution is one of our flagship practices. As you can see from the graphics on the screen, we have over 135 attorneys that specialize in resolving international disputes, including investment disputes. We currently have over 100 or approximately 100 ongoing arbitrations. I think the 98 is a little outdated. And the value of those arbitrations that we're currently managing exceed $23 billion in value of the disputes. So we're pleased that our clients trust us with their most important disputes. And then one thing I think is interesting, if you look down to the bottom right, we do represent 10 sovereigns in the resolution of their investment disputes. And so we understand how states defend the types of claims that we're talking about today. And that provides, I think, again, some unique insight for investors. Next slide, please. This is just a very brief list of some of the recent investment arbitrations we've been involved in the energy sector. If you'd like more information on these types of cases that we've worked on, or other investment cases we've worked on, you can reach out to Tatiana, you can reach out to me or Jose, and we'd be happy to provide you with some more information on Squire, Patton, Boggs's investment treaty practice. All right, but with that, we'll turn to the substance of the issues today with Jose. Thank you.
Thank you, John, and it's a pleasure to be sharing this afternoon with Tatiana and the Hillmont Partners team on this webinar on such a topical issue, which, as Tatiana already mentioned, does not only concern Ukraine, but other countries such as Spain, and very recently also Mexico has been added to the list of countries where renewables are being threatened with measures that, of course, tend to reduce the value of such investments. We're now going to enter into the meat of our discussion, and as an introduction, we would like to first differentiate when we are discussing about international dispute resolution, which is today what really means is international arbitration. I mean, there are other dispute resolution mechanisms that are not jurisdictional, where you have a result that is not binding, or even if it's binding, may not be enforceable in courts. Those types of measures, we're not going to devote too much time to those, although there is some reference to some of those in the Energy Charter Treaty, which we're going to mention. But in terms of international arbitration, which is nowadays the main dispute resolution mechanism when it comes to international, with foreign investment and international commerce. There we need to make a distinction. And the main distinction that we need to make for purposes of today's discussion is between investment arbitration and commercial arbitration. As you may know, many contracts, most contracts will contain a choice of jurisdiction or a choice of dispute resolution forum in those contracts, in the same way as they will contain a choice of applicable law. And very often when we're discussing issues in the international sphere, when they relate to international commerce, those disputes will be resolved by arbitration. And the reason, there are perhaps three main reasons, particularly when we're discussing the sector, the energy sector. The first one is that arbitration will provide the parties coming from different countries with a neutral venue. So parties will not have to discuss their issues or submit their issues to state courts from one of the different countries. Sometimes it's very difficult to agree to resolve disputes in the other side's jurisdiction. The second is that arbitration is a system whereby the parties will choose who the decision makers are. And for highly specialized sectors such as energy, that provides an advantage that state courts do not provide, which means you're going to hire specialists in order to decide your disputes. And that, again, as I said, in sectors like energy, brings a lot of value, and it is one of the most valuable aspects of arbitration. And the third is that awards are usually enforceable through probably the most successful international treaty there is, which is the New York Convention on Enforcement of International Awards. And the power that an award receives through the New York Convention is something that no state court decision will ever have. With an international award, you can go to more than 150 countries, and with a fairly simplified procedure, enforce an award in those countries. Again, in order to do that with a state court decision, you would need to have usually a treaty, and there are not so many of those treaties available. So that is again one of the reasons why in the international sphere, companies will choose arbitration for dispute resolution. So in terms of those contracts that I was discussing, usually you will have an arbitration agreement that will deal with whatever dispute arising out of that contract. And under the provisions of the PPAs, there is, or at least the guaranteed buyer's template PPA, which you will see in the screen, there is an arbitration agreement referring the disputes to the ICC International Chamber of Commerce, which has its seat in Paris. So normally the disputes that will be resolved before that fora are those disputes that arise out of that contract, which is basically, failure to perform the obligations contained in that contract. Here, just as a matter of an example, we say, well, unpaid invoices is one of those breaches. Now, Tatiana spent a very good time explaining about the guarantees that investors are usually offered by countries in order for them to come to invest in their countries. And very often those guarantees are also contained in international treaties that are signed between the host state, that is the state that is receiving the investor and the investment, and the country from where that investor comes from. And those treaties can be either bilateral or multilateral, and they will provide some protection for those investors in order to promote those investors and encourage those investors to go and invest in the host country. Perhaps the most important of those treaties in the energy sector, and at least in the region, particularly the region concerning former Soviet countries, is the Energy Charter Treaty, because it is not only an investment treaty, a treaty that encourages and protects investments, but it is a treaty that is focused on the energy sector. Now, just as a matter of a little bit of history, this Energy Charter Treaty entered into force in 1998, and the idea was to provide a stable framework to stimulate economic growth, liberalize international investment and trade in the energy sector. There are approximately 50 contracting parties to the Energy Charter Treaty these days, and the first international arbitration case that was brought under the ECT is the so-called case AES versus Hungary, which was registered in 2001, and the first award that was rendered was in 2013. In 2003, it's the case between Nikbom and versus Latvia. But ever since, we've seen a growth in the number of cases that have arisen from the Energy Charter Treaty. And basically, as Tatiana mentioned, it is Spain now that has probably the highest amount of investment arbitration cases related, most of them to the energy sector, and particularly the renewables sector. Now, it is important to understand what are the protections that an investor receives, an investor coming from one of the signatory countries of the Energy Charter Treaty receives under such a treaty. Now, there are basically four protections, at least the most well-known protections when it comes to foreign investments. First, we have fair and equitable treatment. Second, we have full protection and security. Then we have the prohibition against unreasonable and discriminatory measures, and the prohibition against unlawful expropriation. And I'm going to speak very briefly about those now. I will change a little bit the order in which I will speak to them about, and I will start with fair and equitable treatment is one of the most important of these protections, and that is a protection that is, we can see, is contained in Article 10.1 of the Energy Charter Treaty. And that article basically says that the contracting parties shall encourage and create stable, equitable, favorable, and transparent conditions for investors of other contracting parties to make investments in the energy sector, and that such conditions shall include a commitment to accord at all times fair and equitable treatment. Now, that standard of protection has been developed over the years, and usually what is included in the notion of fair and equitable treatment is the obligation for a state to act consistently and transparently, to accord due process, to refrain from arbitrary or discriminatory measures, and to ensure stable and equitable conditions. Some tribunals have, in a way, tried to define this treatment, and what they basically require is that states' acts or omissions must not be manifestly unfair or unreasonable. So that is more or less the standard that we're speaking about. Now, that there are other concepts that have been very much discussed recently as to whether such concepts are involved or included in the notion of fair and equitable treatment, and which Tatiana has already referred to, a very important one in this area, which is the investor's legitimate expectations. And here we've seen tribunals taking different approaches as to the importance of the investor's legitimate expectations when deciding on the standard of fair and equitable treatment. There is a very famous case under the Energy Charter Treaty, which is Electrable versus Hungary. According to the tribunal in Electrable, the fair equitable treatment is probably the most important protection that is afforded under this standard. Whereas other tribunals have taken a different approach and not necessarily have said that the expectations are the most important issue that is protected, but they have decided that it is a relevant factor to the determination of fair equitable treatment, but it is not the most important factor. And that decision, tribunals that have taken those decisions include Sharron versus Spain. Now, what it is that we're talking about when we're talking about legitimate expectations? And here there is perhaps a difference between what would be explicit representations that have been made to the investor, and then the question is whether implicit assurances and guarantees would also be contained in that legitimate expectations notion. In Electrable, the tribunal found that while specific assurances given by the host states may reinforce the investor's expectations, such assurances are not always indispensable. So in a way, Electrable has taken the view that those assurances not only have to be established in the law, as the ones that Tatiana has already referred to, but there are also some perhaps implicit assurances that the investor can argue that it had at the time when it made the investment in the host country. Now, there has been sort of a also, let's say, a tension, which is very relevant also to the topic that we're discussing today, which is, on the one hand, what is expected from the host country is a certain stability of the legal framework. But on the other hand, it has also been recognized that the state has a legitimate right to regulate. So it's normally that tension that will be always discussed in these types of cases. One other notion that may be included, or that is often included in the fair and equitable treatment standard, is the one with respect to denial of justice. Now, I will move on to the full protection and security, which is also contained in Article 10.1. And basically, full protection and security, what is important to bear in mind is that this is not only related to physical security, but it also includes legal security. However, we have not seen many cases, at least under the Energy Charter Treaty, or at least publicly under the Energy Charter Treaty, where the full protection and security breach has been argued or alleged by the investor. Then there is, of course, the notion of unreasonable and discriminatory measures. Those protections basically relate to treatment between like persons, when like persons are treated in a different manner in similar circumstances without reasonable or justifiable grounds. And that is very related topic to the national treatment issue, which we see in the screen. in the sense that the host state must grant investors the same treatment that is given to its nationals. So when there are measures that tend to benefit nationals in detriment of the rights of the foreign investors, that's when the breaches to those protections may occur. Now, in certain jurisprudence, one case, which is AES versus Hungary, the second case, I mentioned earlier the first case, the tribunal identified two elements to determine whether the state's acts may be unreasonable. And there, again, we see a tension between the existence of a rational policy. Tribunals will analyze what the policy of the state is, but also the reasonable of the state's act relating to that policy, and also the correlations that you may find between the policy and the measure that was adopted to achieve that policy. Those are issues that will be considered by arbitral tribunals when they are discussing these standards. And then, of course, we have expropriation, which is perhaps the most well-known standard of protection under customary international law. And I think there is, under the Energy Charter Treaty, and this is very common in other treaties as well, there is an acknowledgement that expropriation can take place if it is done in the public interest, if it is not discriminatory. So again, here the notion of discrimination, if it is carried out under the due process of law, and if it is accompanied by the payment of prompt, adequate, and effective compensation. So here we have the typical case of an expropriation, which is called the direct expropriation, and under the Energy Charter Treaty, we have cases like Kardasopoulos versus Georgia, where basically what the government did was take away the claimant's concession to distribute oil and gas in Georgia. Well, that is an example of a direct expropriation. Perhaps a more subtle way of expropriation, which is the so-called indirect expropriation, is what we saw in the case of UCOS against Russia, where there were a series of measures of tax nature, and the tribunal came to the conclusion that those measures were not issued to collect taxes, basically, but rather to bankrupt UCOS and appropriate its valuable assets. That was the conclusion of the tribunal in that case. Again, expropriation was dealt with in Electrabel, which I already mentioned under the Energy Charter Treaty, and also in Sharron versus Spain. And basically here, what we're looking at is at measures that may have a substantial effect on the property rights of the investor. And that is, I guess, the standard that some tribunals have argued that needs to be met in order to come to the conclusion that certain measures constitute indirect expropriation. Now, moving on to who actually qualifies for protection. Here, obviously, what we are discussing is the issue as to who is an investor under the Energy Charter Treaty. And that is usually a topic which is related to again, to the definition of investor. It is well covered by the Energy Charter Treaty in the same way as it is covered by other investment protection treaties. Now, the ECT's definition of an investor includes any natural person who is a citizen or permanently resides in a contracting party in accordance with its applicable law, or a company or other organization incorporated in accordance with its applicable law. And here the issue is what is the criteria to understand particularly not with respect to natural persons, but to companies. What is the criteria to understand whether an investor is a national of the country that is a signatory to the ECT? And the question here is whether arbitral tribunals need to look beyond incorporation. And some tribunals have said that under the Energy Charter Treaty, they don't need to look beyond incorporation. So you may well have a company that is incorporated in Luxembourg, for instance, and that was the case in Sharron versus Spain. And it doesn't matter who the ultimate owners of that company are. What matters is that the company is indeed incorporated in Luxembourg, and that is basically what the issue has been for tribunals that have decided this issue under the Energy Charter Treaty. Now, obviously, there is also an issue as to what is actually protected. And here, what it is actually protected is, of course, the investment. So the definition of investment under the Energy Charter Treaty is important for such purposes. The ECT's definition of investment covers is very broad, and it basically covers every kind of asset owned or controlled directly or indirectly by an investor, and enumerates several categories of investments protected by the ECT, including tangible and intangible property and property rights, a company or business enterprise, equity participation and debt in a company or business enterprise, claims to money or contractual performance having an economic value and associated with an investment, intellectual property, returns, and rights conferred by law or contract, or by virtue of licenses and permits. One issue that has been perhaps clarified by arbitral jurisprudence, in particular the case of Electrable versus Hungary, is that an investment under the Energy Charter Treaty needs to be associated with an economic activity in the energy sector. As I said before, this is the whole purpose of the Energy Charter Treaty. So it has to be an energy-related investment, and that is a very important part of the definition of investment. Now, the issue of debts is important one, and it's a relevant one. Can a debt arising from a commercial contract be considered as an investment? There have been some tribunals that have discussed this issue, particularly in the case between Energolians versus Moldova. In that case, the tribunal by majority found that the right to claim money for an unpaid debt for the supply of electricity was actually an investment pursuant to the Energy Charter Treaty. So this is a very important case. It is a very interesting case because it's one of those odd cases in international arbitration where we see that the majority was actually formed by the co-arbitrators. The dissenting arbitrator was actually the presiding arbitrator, which is something very rare in international arbitration. And what the chairperson of the tribunal did, he disagreed, and he said that a debt acquired under an electricity supply agreement was not a qualifying investment, and dissented on those grounds. And actually, that award, we're going to be discussing about enforcement of awards later on, and annulment of awards. That awards was actually set aside in 2016 by the Parties Court of Appeals, which actually agreed with the opinion of the President. So that is clearly an issue that is pretty much disputed. Let's put it that way. In that respect, I guess I'm not going to. In the interest of time, I guess what's important when we're trying to define who can actually claim protection under the Charter Treaty. Again, I think it is important here, and we will look at it in the next slides. Is the different companies that actually can claim protection under the ECT. The upstream investor that is a national of another contracting state may bring a claim for losses. And this is true if the investment was indirect. For instance, the foreign company's interest is through a holding company organized in a non-contracting state, for instance, and you can see the way in which that would basically work. And then we can see in the next slide, we can see another way in which by establishing upstream foreign control, the investor may be able to seek damages for all of the harm suffered by the investment, rather than just the percentage attributable according to foreign ownership rights. So that is a way of basically being able to claim for all of the harm suffered by the investment, and not just the percentage that foreign company may have in the way in which the investment has actually been organized or structured. I think that I will leave it here, and then I will actually give the floor to John, to my colleague, to continue and entering more. We've been discussing more or less substantive issues. We're gonna move now to more procedural aspects as to how to use arbitration under the ECT to preserve investor rights. John, the floor is yours.
Thank you, Jose. That was very detailed and much appreciated. As you can see on the chart that's on this slide, and this is really picking up where Jose left off, we're going to talk a lot about the application and the insights that we can gain from the cases that were brought against Spain. And so the chart shows you sort of every single filing of a claim under the ECT since 2001. As Jose mentioned, it was established in 1998. So this is basically the full spectrum of cases where investors have utilized the ECT to protect their investments. And in the red line is specifically renewable energy. And so that we see for the vast majority of the history of claims under the ECT, you're looking at a handful, approximately, maybe a little bit less per year, filed against states under the ECT. And then we see this spike in renewable cases after 2000 and just after 2012, and it's only now just settling down. And as Jose mentioned, that spike is in large part measure against Spain, cases filed against Spain, arising out of frankly very similar measures that country took against the renewable energy sector. So next slide. So again, without repeating what's been said, and as many of you may know in the industry, Spain offered these incentives to the promotion program for renewable energy in the early 2000s, and they began to run up large deficits, specifically in the feed-in tariff. And so then beginning in 2008, and then again 2010, 12, and further changes in 2013, the government was forced to take regulatory action to roll back the incentives offered in the industry, and to do so retroactively, which is So again, something that Jose mentioned is very important when it comes to analyzing your substantive protective measures under the treaty. So they eliminated these incentives retroactively on businesses that had invested retroactively. Now, one of the things that I think is really interesting to consider as we start this process in Ukraine is that first bullet point that says the estimated amount of total claims brought against Spain is circa 7.3 billion US dollars. But at the time the government started to take these measures, the deficit it had run up was about $20 billion. So even if every claimant was fully successful on all of their claims against the government of Spain, Spain still has an economic interest to maintain those regulatory changes. So the mere threat of bringing claims, a wave of claims, is not necessarily going to be enough to incentivize the government to make to stop their changes or to stop its current path. And again, one of the key takeaways from the Spain cases is even though there are these sort of multitude of substantive protections that are guaranteed or applied for under the ECT and other multilateral, bilateral investment treaties, the key one that we've seen come out of and be most advantageous to investors in the Spain cases is the protection of fair and equitable treatment. Next slide. So this is what one of the tribunals did in one of the larger awards that came out in May of 2017. And this quote, I think, sums up the tension that Jose was talking about, but it focused on the legitimate expectations of the investor. And what it basically concluded in siding with the investors and awarding the investors, or finding that the government of Spain had violated its international obligations, was that when making the incentive program, the regulators knew that the incentive program would entice investment, and that investment was by definition front-loaded. That investors would put the money into investments in Spain on the understanding and the expectation that legal system would be stable long enough for the investment to make financial sense, and that by changing the rules of the game years later, 5-6 years later, they have frustrated the reasonable expectations of the investors, and that's where liability has been found, and that's where investors, as a practical matter, have been most successful in pursuing similar claims against Spain. So if we move on to the next slide as well, if you can establish liability, what kind of damages can you bring? What are you entitled to as an investor under the ECT? And the ECT, like other bilateral investment treaties and multilateral investment treaties, subscribes to the principle that's well established in public international law that damages should wipe out the consequences of the illegal act. In other words, an investor whose investment has been frustrated by the regulatory issues that we're talking about is entitled to be compensated as if those regulatory issues had never been taken, which sounds fantastic. It should put you back in the situation you were in, but for the actions of the government. It is important to note, however, that you have a burden as the investor to prove those damages to a reasonable degree of certainty. So it's a reparation standard that should put you back in the situation you were in, but for the government's actions. But once you've established that, the burden is on the investor to quantify those losses with certainty. Next slide. And as Tatiana talked about, as I think Jose mentioned to a lesser extent, the types of damages are exactly the kind of damages that any investor would need in order to be put back in the situation they were but for the illegal measures. And those include lost profits over the expected life of the investment, sunk costs of the investment, the money that you've had to put down to build the infrastructure, to build the physical plants, to pay the employee salaries, all those types of things, contractor fees. In addition, we talked a little bit about the difference between commercial arbitration under a contract and also investment claims. To the extent that the PPA agreements, investors would have financial losses from those agreements, those can be brought as damages under the ECT should you prevail on liability. Finance costs. Finance costs is not really one that's talked about a lot, but obviously if you've taken out loans, if you've financed projects in the Ukraine for these renewable energy projects, whatever costs that you've incurred through financing or penalties, oftentimes penalties are a big fee that, once the value of your investment's been harmed, once the liquidity of the project is impaired and you can't pay your financing costs and you incur fines, those can be claimed as damages. And then one of the things that's a little bit unique to arbitration in general, and including investment arbitration, is that when the case is over, you can claim essentially as a damage, but it's called a cost, the legal fees that you've paid your lawyers, the costs for your experts, which can be a lot, and the expenses. So while, as we go to the next slide, or actually, so down the road a little bit, we'll talk about cost. You can actually get your attorney's fees back. Some of the practical considerations with respect to the ECT, and one of the notable ones that investors should be now considering today, if not yesterday, and certainly tomorrow, is that the ECT has a 3-month cooling off period. And what that means is no investor can initiate a claim if they haven't put the government on notice of that claim and waited for 3 months. So a lot of people have been writing about these and talking about these measures and the potential. I think that I've read in an article that they called it an avalanche of potential claims against the government. It's not going to be an avalanche, it's going to be a race. And it's going to be a race because everyone's going to have to wait for the 3 months. And then as soon as the 3 months is up, that will obviously take you, if you file your 3-month letter now, that would take you past the anticipated ratification of the domestic law. There will be a race by investors who feel like they need to file an investment arbitration to protect their rights. And they will begin doing so probably immediately after that law is ratified, if not before. And investment arbitration is a relatively small universe. The claims that were filed against Spain, I think there was 43 investment arbitrations filed against Spain, at least 43. Unusual to have these sort of mass claims. And the system, frankly, has to absorb sort of an inordinate amount of increase in claims. And what that means is every investor who files a claim is going to be looking for a new tribunal. And tribunal members will then start getting conflicted out of cases. And so the first to file the cooling off letter will be the first that are able to file their arbitration, which will be the first investors to be able to constitute a tribunal, move forward with their claim. And that's, again, particularly important here where we have, the chart on the right may not mean a lot to many people. It's a list of influential names in the investment arbitration world who serve as arbitrators. And these arbitrators have specifically served on cases involving the ECT claims against Spain. So as investors in these circumstances are going to look to constitute their tribunal in 2, 3, 4 months' time, you're going to want to put on your tribunal investors who have come down on at least the investors' belief of the right side of fair and equitable treatment. Jose again talked about that tension on legitimate expectations. Is legitimate expectations enough to tip the balance in the favor of the investor? Well, we have a pool of arbitrators who have already decided that issue. And so if you're going to be a foreign investor to file a claim in this circumstance, you want to be sure that you try to get one of the arbitrators who was been on one of the Spain cases and has made a decision on that issue that would be favorable to the investor. And also, one of the things that you've seen in Spain is some cases have gone both ways, again, as we talk about. And if you can be on the front end as opposed to the back end of the investors to file, you reduce the risk of having to deal with cases that come out adversely to investors on this particular issue. Next slide. So the practical considerations of filing an investment arbitration. And again, if anyone has questions, please send them into the chat box and we'll address them. But without going into too much detail, the trigger letter is the first step. It's also important to note about the trigger letter is that it is not necessarily a legally binding document of any kind. It doesn't initiate an arbitration. You can send a trigger letter today or tomorrow, and 3 months from now decide not to file a claim. And that's one reason why we would really advise you to consider doing so sooner rather than later, because the benefit of filing the trigger letter is that you're ready to go whenever you make the decision. If on the other hand, you wait until you're ready to file until you send the trigger letter, you're then behind the 8 ball, and you've really gained nothing by waiting. Once you've triggered and once you're able to initiate the arbitration, essentially you have 3 months to constitute the tribunal after the request for arbitration is. And sorry, I just saw one question pop up, and I thought I could address it, and I'll let Jose jump on this as well. The question is, why do we discuss the ECT and not the BIT? Really, the difference between the ECT and the BIT is essentially that the ECT has been signed by circa 50 parties. And therefore, if you're an investor of one of those 50 state parties, you can bring a claim under the ECT. A bilateral investment treaty between one country and Ukraine, whatever that other country is, oftentimes will provide similar protection as what we're talking about here. And it shouldn't vary greatly. But as Jose mentioned, the ECT is specifically about energy. And so it does have some factors in it that if you are a resident of an ECT signatory, it would be advisable to bring the claim under the ECT as opposed to your BIT. Of course, if you're in a country that has a BIT but not a signatory of the ECT, then obviously you'd need to use the BIT. And I hope that answers your question. But generally, we're speaking about it because it's used more for this type of dispute. And it is more applicable to more investors. But it's a good question because you could certainly do exactly what we're talking about with other BITs that would be applicable to you and Ukraine. So just going back to the practical considerations, what I would say is 3 months after you file your notice of arbitration to constitute a tribunal, generally, give or take, and then you go into the real heart of an investment arbitration. And an investment arbitration is essentially both sides get to write 2 written submissions. Those written submissions are generally lengthy, and they are supported by hundreds, if not thousands, of pages of factual documents and witness statements and damages experts and or technical experts. And so each party is usually given somewhere between 3 to 6 months, depending on the complexity of the case, to write its submission. So you do two, usually the claimant will file its opening memorial or statement of claim within 4 or 5 months after its request, the constitution of the tribunal. The respondent state will then file its response, and then there'll be a period of document production where each party asks each other for documents that are only in the possession of the other party, and then you do 2 more rounds of filing. That whole process could take, again, depending on the size and complexity of the case, as quickly as 12 to 18 months. So it is a lengthy process. And then, usually within a month to 2 months of the last written brief, maybe 3 months, you'll have an oral hearing on the claim where you bring witnesses, experts, and make legal arguments for about a week, generally speaking. And then after that, you have to wait for the tribunal to publish its award, and that could take anywhere from 6 months to a year, depending again on the complexity and value of the claim. So all in all, I mean, again, a smaller case could be handled in 18 months, 2 years with the award, and larger cases that can get into the billions of dollars quite often, obviously take a lot longer. Next slide. Practical considerations, we've been talking a little bit about this on the edges, but suing a sovereign government can be a costly enterprise. But again, the cost, it's difficult to talk about in the abstract because the cost can depend greatly depending on the complexity of the case, the factual picture, and the size of the requested damages. Just by way of example, using the Spain cases again, in a very large 290 million euro case, the investors incurred almost $12 million in attorney's fees and expert costs. In a smaller case, for 30 million, that number was 3.5 million. So it's expensive, but if you look to the right in that pie chart, again, this goes back to the principle I was discussing earlier, which is in just over half of the cases decided against Spain, Spain was ordered to pay the costs of the investor just over half the time. And then finally, in addition to your legal costs and your experts' costs, the administration, which is basically the tribunal members' fees, and the institutional costs for administrating the costs can be about $1 million per ICSID case, PCA case, which is split evenly between the parties. So the Ukraine would have to pay half. So that's usually about 500,000. Again, it depends on the size and the complexity of the case. Smaller cases can be a little bit less than that, but it's also a practical consideration in choosing under the ECT. You can bring it through the ICSID administration, you could do PCA administration, and there's different cost levels, different ways to manage costs between those two. Next slide. One innovative way to sort of manage the high cost of bringing an investment arbitration against a sovereign is to do a collective claim. Collective claims are not widely used in investment arbitration because, generally speaking, investments are not similarly situated. A lot of investments, I'd say the majority of investments, involve infrastructure projects and that type of things that are unique between a single investor and the state. But it has been done a handful of times where investors that are similarly situated have brought claims in one arbitration, and in that way they've been able to share the costs of that arbitration. And specifically, it was done recently in one of the cases under the ECT against Spain. And that's the case on your right there is the PV Investors v. Spain, and the preliminary award on jurisdiction the state of Spain actually challenged the right to bring a collective claim. So in 2014, the tribunal denied that jurisdictional objection by Spain and allowed the claim to proceed as a collective claim. And that claim ultimately wound up in an award in favor of the collective investors in 2020, just this year. Now, I think careful consideration needs to be given in doing a collective claim. You really want to make sure that the investors that you essentially partner with are similarly situated, that the factual pattern is substantially the same, that there aren't glaring weaknesses in some of the investors' jurisdictional rights. And so that you can really streamline the process and not have the process hijacked by attacking individual investors' right to be there and having that sort of weigh down the rest of the investors' claims. But it is an innovative way to share the cost, which, as we mentioned, can be high in these types of claims. Next slide. And when we get to this slide, I'm going to hand it off again to Jose, but I had noticed that there was a question submitted about, and it seems to have been, I seem to have lost it in the Q&A box, but Jose, I think there's a question about whether or not you can bring this may be it here. So I interpret this question perhaps to mean, if you bring a claim under the ICC clause, does this exclude claims under the ECT?
Correct. No, and actually what we need to understand is that the nature of the claims are totally different. The claims that you can bring before the ICC are of a contractual nature. So what you're claiming before the ICC tribunal is that there has been a breach of the contract. Whereas when you bring a claim under the ECT or a bilateral investment treaty, what you're basically doing is bringing a claim against the state who may be responsible for your contract being left without value, because sometimes the contract is in and of itself the investment, but the claim is for a breach of an international obligation. So it's separable. Before the ECT, you're bringing claims for a breach of the state, for the breach of an international obligation that arises out of the ECT or of another international treaty. Whereas when you bring a claim to the ICC tribunal, you're basically discussing the particular issues of the breach of the contract. So you can actually bring two separate courses of action, and one does not necessarily exclude the other.
And then there was one question, just Jose, before you go on with the the next section. There's a question on damages that I'll just address before we move on. Can a non-constructed but ready for construction project that has debt financing, down payments for equipment, etc., also claim lost profits? That's a really good question. Typically, as a claimant, the answer is you can claim whatever you want. The difficulty is proving it. So you are not going to be foreclosed to bring lost profits, and investors have been and can be successful in bringing claims for lost profits where the investment has not become operational. It is more difficult, obviously. Many tribunals have expressed skepticism of awarding lost profits for businesses that are not a going concern. The difference between where you succeed on that and where you fail is really factually specific. And so it's a bit difficult to answer that. I think the simple answer is you can bring the claim, certainly, whether or not you will succeed on it or have a likelihood of success on it is very much factually dependent. And I'll just briefly go ahead in one more area and say where it would be uncertain. The key criticism is where it would be uncertain as to whether or not those profits would actually be realized. And so there are cases where an investor may have a contract, and that contract is sort of a guaranteed, purchase price or a construction contract to build something, and there's no doubt that if the project was completed, that it would be profitable because it's not a unique object or anything like that. But anyway, it's a very factually specific question. It's available, but it's all about proving the viability of the future profits.
Very good. So just going to address very briefly before moving on to one important topic, which is enforceability or enforcement of awards. Just address very briefly what an ICC arbitration would be. And for those purposes, it's very interesting to have had the question already about the difference between claims under an international treaty and claims under the ICC clause. Obviously, before you bring any claim, you need to make sure this is going to be relevant for the topic of enforcement and setting aside proceedings. You need to make sure that your counterparty, has assets against which you can enforce your award. So that is a very key analysis that you will need to to engage in order to decide which way and which courses of action you're going to bring. And here I would like to perhaps complement my answer to the previous question, because at the end of the day, it has to do with damages. And you probably saw in one of John's slides previously when he was discussing what kind of damages under the ECT an investor can claim. An investor can claim damages eventually for contractual losses. What I've seen in the past with respect to parallel proceedings, let's say you initiate an action under the ICC, as I said, you can do that because the nature of those claims are contractual. And in parallel, you can actually bring an international claim under the ECT. What normally will be required is if, in terms of damages, the nature of the damages that you're asking may be seen as being the same. Usually, arbitral tribunals will not allow you to do some sort of double dipping, double recovery. And in a very prominent case, which is PDVSA versus ExxonMobil versus PDVSA, the concession agreement that was at stake, which also formed the investment, did provide for a clause under the ICC, an ICC clause as well. And there, ExxonMobil decided to bring claims at the ICC for contractual breaches, but also before ICSID for international treaty breaches. And what the investors said in that case to the tribunal, basically to both tribunals, was that any amounts that they would recover from the ICC tribunal, they would deduct them from any amounts, particular, of a similar nature or of the same nature that they were actually claiming before the ICSID tribunal. So there may be an overlap when it comes to the nature of the damages that you can request to both tribunals. And in that respect, an investor will probably take the same approach that ExxonMobil took in those cases, and probably that's going to be what is expected from an international tribunal, particularly the one under the Energy Charter Treaty, usually for issues of timing and the length of those cases. Usually is the tribunal that will usually issue the award later on. So normally those are the claims that were going to be deducted from the award of the investment treaty tribunal. Of course, when you have an ICC arbitration agreement, you are already before a different institution. What I can say for purposes of the of investors, considering whether to bring an ICC claim, is that in that respect there is no concern in terms of the institution. Of course, I'm a little bit biased speaking about the ICC because I spent a big part of my career working at the ICC. But don't believe me. I guess you can believe others and read everything that is written, in the sense that basically the ICC is today the world's leading institution when it comes to international arbitration. It is an institution that is headquartered in Paris, but has a physical presence in every single continent. You have case management offices basically in every single continent in the world. So it is a very trustworthy institution, and that is often also a very critical issue to consider when you're deciding whether it is actually worth pursuing a claim, a contractual claim. Again, I would say the first consideration that you may have is you need to evaluate who your counterparty is. Will you have an award that you can actually enforce against that party? That is what the real analysis that you have to do. And of course, then you will have to analyze whether, going to that institution, is it a trustworthy institution? And in that case, I think that criteria is met with the ICC. One of the perhaps the most interesting features of ICC arbitration is that the ICC will scrutinize the award that is issued by the arbitral tribunal before sending that award to the parties, and that offers a guarantee to the parties, and particularly to the investor who is expecting to receive an award to be enforced, that there will be no vices or no problems with that award that then will cause or be a concern at the enforcement or at the annulment stage, which we're going to perhaps discuss now. And I think that is perhaps the most important feature of the ICC. It's the guarantee that your award will normally be of a high quality award and that will not contain vices that will risk its enforceability or its validity at the end of the day, which is what any investor would want to have, when going through arbitration. So I think with that brief comment on ICC arbitration, we can move on to the next slides. At the end of the day, none of what we've been discussing for the past hour would be important if you don't have an award that you're going to be able to enforce. So at the end of the day, enforcement, recognition of the award is of utmost importance. And I am, of course, conscious of time, and I won't go into too much detail with these slides. Of course, if there are any questions, I would be glad to answer them, but we have other material to cover, so I will try to be brief. Enforceability of the awards is also related to the course of action that investors will be able to choose under the Energy Charter Treaty, but usually also under any bilateral investment treaty. The treaty will give you choices when it comes to international arbitration. Now, the choices offered by the Energy Charter Treaty are: you can bring a claim under the UNCITRAL rules, you can bring a claim under the ICSID rules, and you can bring a claim under the Stockholm Chamber of Commerce rules. And you may be wondering, what is the difference between those? What is the difference between those systems? And there are basically the differences will be perhaps important for the enforcement stage. When you're in ICSID, you are within a system which is self-sufficient. An award that is rendered under the ICSID system will have the same weight as a decision from the host state, a decision basically from the Supreme Court of the host state. And that decision will be enforceable through the normal proceedings that are applicable to enforcement of those decisions in that host state. So I guess that's one of the big advantages of ICSID. Now, when you choose to go to UNCITRAL or to Stockholm, you're under another system of arbitration, which I would say it's the New York Convention system of arbitration. So if you choose that course of action, the award that you will receive is an award that you can then go and try to enforce to any of the 155 countries that have signed the New York Convention. So in that respect, you have, I would say it's not a given. For strategic reasons, an investor may well choose to go to UNCITRAL or Stockholm to be able to benefit from having 155 countries to enforce an award under the New York Convention. Another difference that is very important with respect to the course of action that you choose is with respect to the validity of the award. When you're under the ICSID system, you can challenge the validity of the award before, again, the same ICSID system. Basically, ICSID will create a panel to review the validity of the award. Normally, you can challenge the validity of an award for very, very, very specific reasons, which are very similar under the ICSID system and under any other arbitration regime. When you're not in the ICSID system, you then need to take into consideration another issue, which is the seat of the arbitration that you will choose. So if you go to UNCITRAL arbitration or you go to the Stockholm Chamber of Commerce, you can choose a jurisdiction, no matter where in the world, to be the seat of the arbitration. The award that is going to be rendered in that arbitration can be challenged, its validity can be challenged in that seat of the arbitration. So choosing the seat of the arbitration will be probably one of the most important decisions that you will need to take if you choose to go down that path. Most arbitration laws in the world will contain the same type of protection and will contain the same type of restrictions for challenging an award, but that is an analysis that you will have to do when choosing which place of arbitration you're going to select for that particular case. And perhaps another aspect that you will need to consider when you are outside the ICSID system is the issue of sovereign immunity. The issue of sovereign immunity becomes important because, of course, you're going to have an award against a state. And the purpose of this webinar is not to discuss sovereign immunity. I guess we can spend a whole day speaking just about sovereign immunity. I guess here the takeaway is that you will also need to consider which jurisdiction you're going to go to enforce your award in. And nowadays, the criteria between different jurisdictions in order for state courts to accede to a sovereign immunity defense in terms of enforcing awards is very similar. It's very similar in the way that normally assets of the states that are used for sovereign purposes are normally protected. You cannot attach those assets, whereas assets of a state that are used for commercial purposes are the ones that you can actually pursue and attach. There will be differences between jurisdictions, but I think that is perhaps the main criteria that the main takeaway from this issue that we can establish here, and maybe perhaps leave it for later for discussions and questions. And again, with that in mind, also you need to when you're deciding which course of action you're going to take, you also need to take into consideration sovereign immunity. And perhaps in order to give the floor to Tatiana now to move on to relief before and remedies under Ukrainian law, perhaps one has to also mention that the Energy Charter Treaty not only gives you options of international arbitration regimes and systems that we have already described, but you can also go to state courts. What needs to be taken into consideration is that if you as an investor go to state courts, then you will have what is called a fork in the road clause. If that's the path you choose, you cannot go back, or you cannot then file an international claim under an arbitral tribunal. So that is perhaps something that can be specified now, and that will serve as a way to then transfer the topic to Tatiana.
Thank you very much, Jose. Thank you very much, John. That was really practical consideration that are of specific interest, as we could see from the chat box. And thank you very much, Tom, for your specific practical questions. I invite you and other attendees to please use the opportunity and ask your questions or concerns you may have throughout the webinar. As we could hear, the similarities with Spain's scenario are really striking, and I would really expect for investors to just protect their rights in investment arbitration. That's very clear and straightforward. And now, I would like to invite my colleague Bogdan Novik, who will briefly outline perspectives of filing lawsuit in Ukraine against the off-taker. And this is relevant for SPVs, for project company with Ukrainian investments, or with those foreign investments, those companies with foreign investments that still have chosen arbitration clause in the PPA with a guaranteed buyer. Bogdan, please, the floor is yours.
Thank you, Tatiana. Good afternoon and a very warm welcome to everyone joining us for this webinar. Today, I would like to share with you some insights and practical tips regarding the protection of rights and interests of investors in the renewable energy sector using remedies available under Ukrainian law. Before we proceed directly to the consideration of specific remedies, we need to understand who qualifies for legal protection. Rights to protection will be available for electricity producers from renewable energy sources with renewable energy facilities that have already been commissioned and are operating, as well as for future electricity producers from renewable energy sources with concluded pre-PPAs for renewable energy projects being implemented. The next question we ought to consider is whether protection is available for investors who have signed a memorandum of understanding. Yes, such investors will be entitled to protection. This issue is a concern for many investors. It is important to highlight that the memorandum is not a binding agreement or other official legal document, but rather it expresses the willingness and intention of the signatories to implement the provisions of the memorandum. In addition, the memorandum itself states that its signing does not constitute a waiver from any available legal remedies. Nevertheless, I believe that the stronger legal position will be held by those investors who have not signed the memorandum. It will express their clear and unequivocal disagreement with the provisions of the memorandum, and consequently with the provisions of the feed-in tariff restructuring law, and will prove that they are acting in good faith. Next slide, please. Let's move on directly to the remedies available for investors in the renewable energy sector. It is possible to outline several types of remedies provided by Ukrainian law: filing a lawsuit to the Commercial Court of Ukraine, filing a constitutional complaint to the Constitutional Court of Ukraine, and lodging an application with the European Court of Human Rights. Each of them has specific features and different rules. Now let's look at each of these types in more detail. The first remedy is filing a lawsuit to the Commercial Court of Ukraine. The opportunity to file a lawsuit to the Commercial Court of Ukraine is fixed in the text of the PPA, namely clause 6.3. The lawsuit should be addressed to the state enterprise guaranteed buyer. And what should be the subject of the lawsuit? Firstly, electricity producers are eligible to demand repayment of the existing indebtedness. As was mentioned earlier, the guaranteed buyer has significant indebtedness owed to electricity producers from renewable energy sources. Overall, level of payments to thermal power plants and combined heat and power plants, as well as to nuclear power plants of state enterprise Energoatom, are much higher than to electricity producers from renewable energy sources. It is a sign of discriminatory approach. However, such actions by the guaranteed buyer directly contradict provisions of Ukrainian legislation. According to Article 9.1 of the Law on Alternative Energy Sources, the state guarantees existence in legislation for the entire period of application of the feed-in tariff of requirements to purchase in each billing period the electricity produced by renewable energy facilities at the awarded feed-in tariff, as well as payments for such electricity in full, on time, and by monetary funds. I should clarify that the debts of the guaranteed buyer include the cost of purchased electricity, as well as fines and penalties for the delay of payments. At the present moment, we already have a few lawsuits against the guaranteed buyer. In particular, Biogas Energo demands repayment of the debt in the amount of 12.4 million Ukrainian hryvnias from the guaranteed buyer for electricity generated by the company in March 2020. And Green Energy Invest demands payment of the debt in the amount of 4 million Ukrainian hryvnias from the guaranteed buyer for the generated electricity. At the same time, I should point out that it would be quite difficult to claim damages from the guaranteed buyer for feed-in tariff reduction, since the PPA does not determine the feed-in tariff rate. The feed-in tariff rate is established by the energy regulator on the basis of the law. Therefore, we can assume that the guaranteed buyer will not violate the conditions of the PPA, and consequently, the rights of electricity producers from renewable energy sources. Nevertheless, if the court of first instance appeal and or cassation courts refuses the reimbursement of damages, the company will be entitled to file a constitutional complaint to the Constitutional Court of Ukraine and an application to the European Court of Human Rights. Next slide, please. The next important question is whether it's possible to demand an extension of the cutoff date in court due to the quarantine. This question is often asked by clients and concerns solar power plants with capacity of 1 megawatt or more, for which the feed-in tariff restructuring draft law proposes to reduce the feed-in tariff rate by 60% from 1st August 2020. At present, we do not see legal grounds to demand an extension of the cut-off date through the courts due to the following. The first measure, in this case, the quarantine, exempts only from liability. However, our case refers to the right of the producer to commission the renewable energy facility until the defined term and obtain the feed-in tariff, but does not refer to the liability. Next slide, please. The next remedy is constitutional proceedings. Ukrainian law defines certain steps for the use of such remedy. At first, if during the consideration of the case, the court establishes the necessity to verify the constitutionality of legislative changes, the court shall suspend its consideration of the case and apply to the Supreme Court. After that, the Supreme Court may apply to the Constitutional Court in order to verify the constitutionality of legislative changes. A very important provision on the prohibition of retroactive legislative changes is contained in the Constitution of Ukraine. According to Article 58 on the Constitution of Ukraine, laws and other normative legal acts shall not have a retroactive effect, except in cases when they mitigate or annul the liability of a person. The state guarantees the incentives for generation of the electricity under feed-in tariff as of the date of commissioning. This means that the application of the respective rate of the feed-in tariff is guaranteed. The feed-in tariff reduction has retroactive effect for operational renewable energy facilities and will worsen their financial position. Therefore, we can state that the feed-in tariff restructuring law will violate the Article 58 of the Constitution of Ukraine. Another difficult situation will arise around the solar power projects with PPAs, since the feed-in tariff for them has not been established, and the reduction of the term for commissioning is intended to be implemented through tariff reduction. Therefore, they have the right to commission solar power plants within 2 years, but the feed-in tariff rate will be much lower. Thus, whether the feed-in tariff restructuring draft law has retroactive changes for solar power projects with PPAs and whether it violates Article 58 of the Constitution of Ukraine are quite controversial issues. Next slide, please. A similar tool is the filing of a constitutional complaint. The right to file such a complaint is fixed in Article 55 on the law on the Constitutional Court of Ukraine. To start with, I would like to outline what is a constitutional complaint. A constitutional complaint is a written motion submitted to the court to verify the compliance of a law of Ukraine or certain provisions contained in the law with the Constitution of Ukraine, which has been applied in the final court decision in the case of an applicant. The constitutional complaint can only be filed by individuals and private legal entities. Theoretically, the arbitral award is a final court decision in the case, but we are unaware of the instances when individuals or legal entities after arbitration applied to the constitutional court with the constitutional complaint. It is important to note that if the constitutional court declares the law unconstitutional, the law or its relevant provisions shall be null and void from the date of the decision of the court, unless otherwise established by the decision itself. The next step should be the adoption of a law which must comply with the Constitution, or the previous wording of the law or the relevant provisions of the law should be in effect. It should be noted that the constitutional complaint mechanism was introduced in 2016, and we have already seen positive decisions in favor of complainants. However, these decisions did not relate to the energy sector. Next slide, please. The next type of remedy is lodging an application with the European Court of Human Rights. It is important to note that such an application can be lodged only after exhausting all available domestic remedies. The application must be lodged with the European Court of Human Rights within 6 months from the date of the final domestic decision. Grounds for lodging an application may be the violation of Article 1 of the first protocol to the Convention for the Protection of Human Rights and Fundamental Freedoms, which states that every natural or legal person is entitled to the peaceful enjoyment of his possessions. No one shall be deprived of his possessions except in the public interest and subject to the conditions provided for by law and by the general principles of international law. In the understanding of the court, the term possessions is broad and includes movable and immovable property, pensions, tax refunds, licenses, securities, etc. I would like to highlight that the past practice of the European Court of Human Rights has been to rule that when a person is confident of achieving the expected result, they have legitimate expectations, and if they act in accordance with the law, the protection of these expectations must be guaranteed. This applies directly to renewable energy producers in relation to the situation regarding feed-in tariff structuring. If the investor decides to settle dispute in arbitration, this will deprive him of the opportunity to apply to the European Court of Human Rights, as when applying to the European Court of Human Rights, the applicant must indicate which articles of the convention or its protocols have been violated by the state. The state acts through the national courts, and arbitration is actually a private court selected by the parties. Therefore, the European Court of Human Rights will refuse to accept such application. These were the main points of significance regarding the protection available to electricity producers from renewable energy sources under Ukrainian law. And thank you for your attention. Tatiana?
Thank you very much. Thank you very much, Bogdan, for your insights. And I would like, once again, before I move on to presenting our survey results, which we held together with Energy Club and A7 Capital, invite our attendees to please use the opportunity and address your questions to our guest speakers. As you can see, to sum up, there are few remedies available, few legal remedies available for investors in the renewables sector of Ukraine. And to my mind, the most secure and protected should be deemed foreign investors qualifying for investment arbitration. And again, for those companies, SPVs, with foreign element less than 10%, still there are legal remedies available, as going to a commercial court of Ukraine and trying to obtain outstanding debts from the guaranteed buyer. There are two other alternative ways, which is filing a claim to the Constitutional Court of Ukraine, but only after exhaustion of all domestic remedies, and also filing a claim to the European Court of Justice. And let me check. I see there should be a question there. So we have one question. What is the definition of commissioned plant? In order to be eligible for the feed-in tariff, must it be connected to the grid? Thank you for your question. So there are certain criteria under the law which require require certain things to be done by the SPV, and I cannot say definitely that actual commissioning one of them, because until now, recently, there was very nice and handy instrument which is called pre-PPA, allowing without actual connection to the grid, still have the green allow to qualify for the feed-in tariff, provided there are title rights to the land, provided there are technical conditions in place and some other. But that mechanism expired in the end of last year. So those companies who have pre-PPAs in place, they still are eligible for green tariff, provided they will be able to get their power plants constructed in time. And it is advisable if it's solar to have that plant constructed by 30 June. Sorry, by July, by the end of July this year. Otherwise, you would have -60 reduction, still eligible for feed-in tariff. And again, for wind, there are still 3 years for having those objects constructed. So generally, for company for SPV to be commissioned, you would definitely need to have a connection to the grid, and the company would need to be fully operational. I hope that answers your question. Anyway, we could follow up with email detailing this. Okay, and if no questions, I would then step into our final stage of our webinar, presenting our survey results. And those market survey has been conducted within recent week by our company together with Energy Club and Existent Capital. We try to outreach as many market players as possible, and we have received a substantial number of feedbacks from respondents, both from those companies that are of pure Ukrainian origin, which constitute, as you can see on this slide, exactly half all respondents, and also we have half of other companies being those with foreign investors. So if again, if we look at the respondent profile, we would see that generally, if the company is a foreign, the foreign investment constitute the majority, so it's more than 50%. And the main question, one of the key question we asked our respondents was if you believe that the current situation actually affected negatively your business or no, and no surprise, the majority said yes, though there appear to be 12% of enthusiasts or optimists claiming they were not really affected. Interestingly, if we talk about damages, because I would expect that if not all, majority of companies would now be involved in assessing the investment, the projects, and actually doing, I would say, something close to the due diligence of their projects and understanding what's the best plan, what's the best scenario to proceed. And one of their key things to do is actually to understand what are the damages, and at least to have rough understanding what's the amount. From the survey results, we understand that this process is still ongoing. As the majority responded, it's really hard to tell what actual damage is, and other respondents believe that they know at least roughly if they are below or above 7 benchmarks. So we suggested for the SEVI 1 million, Euro 5, and 10 and 20 respectively. Another question was if the company or group of the company with portfolio project has developed any viable strategy or action plan in respect of anticipated feed-in tariff costs and changes, and other changes which also are relevant and affect economics of the project. So I was, honestly, I was a bit surprised learning that the majority of respondents said that not yet, and they are in the process and following the situation closely. So which still means that the process is ongoing, obviously, but there are also a small percent of respondents who said that they would definitely proceed as planned under their pre-PPAs, and they do not plan, are not involved in any strategic planning at the moment. And for the sake of time constraints, I would probably skip some of the slides detailing on some very important. It is very interesting that for the question, if you're considering a claim for the protection of your rights to Ukrainian courts or to international arbitration courts, quite big, substantial amount of respondents replied they are not certain yet, meaning that in parallel with assessment of their project portfolio, they are considering optimal legal strategies. And I believe there should be more certainty whether it's worth going to investment arbitration after our webinar. If we could go to the next slide, please. And yeah, I think this question is somewhat generic, but still it's interesting to know that almost 1/3 of respondents are ready to protect their rights and to make costs and expenses as much as reasonably needed. Again, if we talk about trigger letter, yeah, there is understanding that trigger letter should be sent and could be sent. So there is some understanding of this mechanism, and I think we can skip these slides. So one of their, if you could also notice, almost 70 respondents believe that it could be still worth joining a collective claim. And if we talk about general how our respondents see their protection strategy, they definitely, and this relates to those companies of Ukrainian origin, they consider all possible options, meaning going to court, going to commercial court, going to European Court of Justice, Constitutional Court, as may be needed. And so I think yeah, this is one of their questions which we ask, and definitely said there is interest in having a collective claim whenever possible. But as our experts have already mentioned, special care and should be paid, and diligent assessment should be made as to claims, the scope of the claims, as to the general standing of the potential co-claimants before actually deciding to have so-called a collective claim, so that the legal positions of co-claimants are getting stronger by joining, but not weakening some of their co-claimants. I believe we are on the very final slide, which is also interesting, and for the question if the current situation affected plans, the answer was no. And this was the question to potential investors, to potential companies which are considering whether to enter Ukrainian market or not. So it's kind of relieving for me that those companies, I would assume, they are in wait for launch green auctions. They will look for how the situation will develop, and are still hopeful for that. And I think for this is, I guess, the last slide. And as you could see here, indeed, almost 70% are interested in green auctions, and 30, slightly more than 30 answer that regulatory changes actually do not matter. And this is particularly true for Ukraine, that overall country risks really have big weight, and the country should work towards diminishing those risks. I think these very interesting findings, which we will make available to our respondents, and so I think this is the last. This is the last survey with results. And on my side, I would like to thank you for your inputs, Jose and John. That was really beneficial to have you as our panelist on the webinar today. And I wish you have fruitful and interesting practice of different cases. And at the same time, I believe that the optimal scenario probably would be to find a good solution meeting interests of the state and securing rights and interests of business community. But from how situation is developing, it is quite obvious for me that at least we would definitely have few arbitration cases, investment arbitration cases. At least that's how I see it. So if you could, if you have any closing remarks, or you would like to share any final tips or takeaways, please do so.
No, we appreciate the request to be here, and we appreciate the collaboration, and I think it was a great program. I think the one takeaway would be is if you can, after watching those slides about where investors are at the moment, if you have any desire or any consideration to proceed with arbitration, go ahead and send that trigger letter now, and then that will buy you more time to consider your options. But there's, even if you're 90% sure you won't, but 10% considering you will, you have nothing to lose from sending the trigger letter.
Thank you, John. That's yeah. Thank you, John. That's really that's very useful takeaway indeed. And as mentioned, those who send trigger letter first have advantage, or I would say even privilege, to choose from bigger pool of arbitrators, right? And so it also provides a number of a number of other advantages. And thank you very much, Jose. If you could share something from your side. I mean, you have your speech was excellent as well as John's, and thank you for so many information. But maybe just one secret takeaway for our attendees who waited till so long and still stay with us.
Well, I just wanted to thank you also for having us. It's been a pleasure. I think John's said it all. I think you know, to decide what to do, it takes time, but to write that trigger letter, it takes very little time. And you know, while you're still considering what to do, if you already have that letter in, that's also a very good tip. Not only because you will have a larger pool of arbitrators, but also because, as we've seen in Spain, the first awards that are rendered then do become sort of like a guidance for other tribunals. So you know, the more awards are in, the more you will have, the more material arbitral tribunals will have to regard and choose from, and that may be positive, but that may not be that positive. So, you know, proactiveness is the key word here, and that's what I would end up with.
Thank you very much. Thank you very much for all your speeches and valuable contribution. Also, thank to Bogdanovic and to other co-organizers that contributed to Energy Club and A7 Capital. And thank you for most our attendees who spend their time and being so active. And wishing you a good day, and take care and keep your investment safe. Thank you all. Have a good day. Bye.
Good.